In early medieval England, justice could mean anything from trial by fire to a group of villagers swearing on your innocence. If you were accused of a crime, your fate might depend on whether your hand healed after being burned or if you floated in a river. This system wasn't just strange, it was dangerous, unpredictable, and deeply unfair. Before the 12th century, England had no single legal system. Justice depended on where you lived, who your lord was, or even who you knew. Some people faced local courts, while others escaped punishment entirely by claiming to be part of the church. Then came King Henry II. He ruled from 1154 to 1189 and believed justice should be the same for everyone, whether they lived in Cornwall or Kent. During his reign, England saw the birth of something new, a legal system based not on local customs or superstition, but on royal authority, evidence, and written law. This was the beginning of what we now call common law. It would shape not just English history, but the legal systems of half the world. And it all started with a king who was tired of chaos. Before Henry II became king, English law was not really one system, it was a mix of old customs, feudal rules, and church influence. The country was divided into small regions, each with its own way of handling disputes. Justice in one town could be completely different from justice in another. There were local courts called shire courts and hundred courts. These were led by local landowners or sheriffs and handled everything from theft to land disputes. But decisions weren't always based on facts. Instead, people used trial by ordeal, like carrying a red-hot iron bar or being thrown into a river. If you survived or healed well, you were considered innocent. If not, you were guilty. It was believed that God would protect the innocent. There were no national laws, no official judges sent by the king, and no written system that everyone followed. In short, justice was personal, local, and uncertain. When Henry II came to the English throne in 1154, he inherited a legal system that was anything but organized. The country had suffered from years of civil war during the reign of King Stephen, a time often called the Anarchy. Law enforcement had broken down, barons had grown powerful and violent, and the king's authority was weak or ignored in many parts of the land. To understand the scale of the problem Henry faced, imagine a kingdom where each local lord ran their own private justice system. People accused of crimes were judged differently, depending on their village, their religion, or their social status. In some places, a person could be sentenced to death for theft. In others, they could be let off with nothing more than a fine. The rules were inconsistent, unwritten, and often based on superstition or loyalty rather than truth or fairness. Henry II, however, was not a king who tolerated chaos. He believed in central control, order, and above all, in the power of the crown. His mission was simple but ambitious: to take justice out of the hands of local barons and churchmen and bring it under royal control. To do this, he launched a series of legal reforms that would transform England's justice system and eventually influence the entire English-speaking world. One of the most important changes Henry introduced was the Assize of Clarendon in 1166. This royal decree marked the beginning of criminal justice reforms that would slowly replace trial by ordeal and local suspicion with investigation and evidence. The assize required local juries to report suspected criminals from their districts. These juries, made up of 12 lawful men from each hundred, a division of a shire, were to present names of those they believed guilty of serious crimes like murder, robbery, arson, or theft. This was not a trial jury as we know it today, but more like a community-based investigation team, responsible for bringing suspects to court. This process introduced the idea that local knowledge could be used for gathering evidence. But guilt would be decided in royal courts, not in village gatherings or baronial halls. It also brought the king's justice to every corner of the country, regardless of local customs or power structures. From this time forward, the law shall follow the king's writ, and not the custom of lords. Assize of Clarendon, 1166. This single reform laid the foundation for the grand jury system. By requiring these reports to be made to royal justices, Henry took control of criminal investigations across England. To make sure these new rules were enforced, Henry established a group of professional judges known as the Justices in Eyre. These men were appointed by the Crown and travelled from town to town on a fixed schedule. Their job was to hear cases, enforce royal law, and spread a consistent system of justice across the kingdom. Another of Henry's major innovations was the development of the writ system. A writ was a short written document from the royal chancery that ordered someone to appear before a royal judge. Writs allowed people to bring disputes directly to the king's court rather than relying on local lords or church courts. Before writs, you needed permission or influence to be heard in the king's court. Now, for a small fee, even a commoner could request a writ for a legal complaint like unpaid debts, stolen goods, or disputes over land. This opened royal justice to a much wider population. It also gave the people a way to bypass corrupt or biased local courts, shifting legal power from the nobility to the crown. Justice should be the same in Cornwall as in Kent, attributed to Henry II c. 1170. This idea that the law must be consistent no matter where a person lives is still a core principle in modern legal systems. Not everyone welcomed Henry's new legal powers. One of the greatest challenges he faced came from the Church, which operated its own legal system and claimed that clergy could not be tried in royal courts. Henry believed that even priests should face royal justice if they broke the king's laws. This brought him into direct conflict with Thomas Becket, the Archbishop of Canterbury and Henry's former friend. Becket refused to allow the king's judges to try clergymen, arguing that they should be tried only by church courts, which were often more forgiving. Henry responded with a new legal policy, the Constitutions of Clarendon, 1164, which tried to limit the church's legal powers. Becket resisted. The dispute grew bitter. In 1170, after a long standoff, Becket was murdered by 4 knights in Canterbury Cathedral. Though Henry denied ordering the killing, he faced public outrage and was forced to do public penance. Despite this tragic episode, the Church gradually lost its grip on criminal justice. Henry's legal reforms continued, and the idea that all people, clergy included, should answer to one system of law gained strength. Another major result of Henry's legal reforms was the slow replacement of trial by ordeal with trial by jury. In the old system, people accused of crimes had to go through ordeals like carrying hot iron, plunging their hand into boiling water, or being thrown into a river to see if they floated. These methods were based on the belief that God would protect the innocent. But Henry's emphasis on evidence and investigation changed how guilt was determined. Local juries now began to play a bigger role, not just in accusing criminals, but in judging them. Over time, the royal courts moved toward what we now recognize as jury trials, where a group of citizens listens to evidence and gives a verdict. In 1215, the Church officially banned trial by ordeal. This decision came after Henry's reforms had already made juries common in royal courts. Without the Church's support for ordeal, and with a functioning system of juries already in place, trial by jury became the new standard. By the end of Henry II's reign in 1189, England had a legal system unlike anything in Europe. It was centralized, written and based on royal authority. It encouraged consistency and fairness by using judges trained in law and applying precedents from earlier cases. The legal reforms Henry started didn't end with him. Later kings like Edward I expanded and strengthened the system, but they worked from the foundations Henry laid. His reforms became the roots of English common law, which was later exported around the world to America, Canada, India, Australia, and many other countries under British rule. Even today, features of Henry's system survive. Public trials, independent judges, jury verdicts, written laws, legal precedent. We often think of kings as warriors, conquerors, or tyrants. But Henry II's greatest legacy wasn't on a battlefield, it was in a courtroom. He didn't just change how England handled crime.